Okay, property, week 3. We'll be looking at the Moore case, Aboriginal perspectives on property, property and poverty, John Adams problem, possession, and Pearson and Post. So to review the Moore case, it was with regards to a person who was having their leukemia treated, and the doctor was taking their cell linings in order to create something of value for research purposes. I'm not sure what. The issue was conversion. If the plaintiff has an ownership interest or not, and if the defendant wrongfully took the property, then there must be damages. So is there ownership in the cell lines? And only the middle court thought that this was the case. The Supreme Court of Canada thought that, no, not the Supreme Court of Canada, this was California, but the Supreme Court there, that no court had decided that you can argue conversion for this type of property, and thus it's not yet conversion. They did, however, agree that on the informed consent issue, that they should have consent to take these cell lines. And their justification was that once the spleen or something is out of your body, there are lots of regulations and limitations to that property. You can't just do anything you want with it. And if you can own a part of your body, you can sell a part of your body. So they were concerned about a marketplace for these sorts of things. Of course, if you say it's conversion, it is property, then there's the marketplace. They thought that there's too much to this, and thus the legislature should look at it. The lower courts, they emphasized that the body is yours and it's property, and we're going to move on it, or the middle court rather. Whereas the higher court emphasized the economic value of the work, labor, and effort put in by the researchers, and of course concerns over calling your body property. The other reason it's complicated is that the court only has the two parties in front of them, so to declare something like property in the body is going to have larger implications, and they don't have the information in order to make that larger decision. Ultimately, in Canada anyway, the Royal Commission on New Reproductive Technologies, overview of legal issues in New Reproductive Technologies Commission, was created, and they got expert testimony from anyone that had an even tangential view on the subject, and they decided against characterizing anything from the body as property. And so all bodily material is sui generis, or within its own class. And I don't know the legal implications of that, but anyway. So sui generis is of its own kind. So within body as property, there are special and unique interpretations are necessary. So the Moore case led eventually to, or in Canada anyway, the Assisted Human Reproduction Act was enacted in 2007, and the act is meant to monitor, to provide Canadians with a system of licensing, monitoring, inspection, and enforcement of activities related to assisted human reproduction in order to protect and promote Canadians' health, safety, and values. It identifies prohibited activities as well as controlled activities which can be performed in Canada. Some require licenses and adherence to regulations. However, some aspects of this were ruled unconstitutional in 2010. They exceeded the federal government's legislative powers. So here are some of the prohibited activities: creating an in vitro embryo, human cloning, pre-selecting or increasing the probability that an embryo will be a particular sex, transplanting a sperm, egg, embryo, or fetus of a non-human life form into a human being, creating a hybrid for the purpose of reproduction, creating a chimera for any purpose, using gametes or in vitro embryos without the consent of the donor, obtaining gametes from a person under the age of 18, or offering to pay or advertising payment for sperm, eggs, or in vitro embryos. So Moore continued. Now, there are some aspects of the common law that mean that this complex situation shouldn't be decided by the judges. The first is that the judges have limited remedies. They have damages, declarations, and through the Court of Equity, they also have orders of specific action and injunctions. So they're not likely to stumble onto a complex regulatory framework with these limited remedies, and sometimes that's what these issues require. So this is why they like possession as a property. So as a side note, possession is an important part of property because it's easy to understand and apply. Again, side note. Second, the court can't order the docket of cases that came before them. So they can't see multiple cases at once, and they don't get really to choose the order that they see them in. So this limits them because they can't escape the consequences of the decisions on little points that they made in earlier cases. So if we look at the Moore case, the researchers who were using the cell lines, they livid against each other. And in that case, the cell lines were seen as property. Now, if they had determined that the cell lines were property in that particular circumstance, what would have happened when Moore took his case to the court? Well, there would have been a precedent that the cell lines were property, and possibly he would have been awarded damages through conversion, and now, things from your body are property. That's a limitation. And lastly, the dispute is only between the two parties. Thus, no third-party interests can be considered, and this has an impact on state ownership, though I'm not exactly sure why yet. Aboriginal perspective on property. The key is, if you think about your social relationships differently, that your definitions of property are different too. So this creates a real issue for the courts. Within Canada, there are very different conceptions of property, and our courts are required to mediate this difference. For example, if time is cyclical and not linear, and land is a community resource as opposed to a private resource, that defines who I am, then there are different legal implications. So when the Europeans came and the Aboriginals were sharing, they were willing to share their land, did they give up their rights to exclude? Did they give up any other rights? Now, if their concept of land is that it's shareable with the other animals and humans, what rights do they in fact give up? Now, and what if land is inalienable? It's not something that can be seen as property. Well, that would have huge implications. So the overlay problem, not until 1973 in the Calder case was it decided that Aboriginal perspective was, I suppose, important in deciding what property is. So previous to that, the policy was to assimilate. And this is coming in the context of the decolonization of African states and the Convention on Social, Political, and Cultural Rights from the United Nations. So in the Calder case, the Supreme Court accepted, that's the wrong spelling, that Aboriginal title is recognized at common law and was not extinguished merely by the acquisition of Crown sovereignty. So this title existed for the Aboriginal peoples who were organized in societies and occupying the land when settlers arrived. So the Calder case decided that the land did actually belong to the Aboriginal peoples. They did have title, and it was not extinguished simply because the Europeans arrived. So Aboriginal property now, according to the Delgamuukw versus British Columbia case, Aboriginal rights are sui generis, and now we also have the issue of the duty to consult. So any changes to treaties or Aboriginal agreements or Aboriginal land titles, or the government has a duty to consult with the Aboriginals. But the key to this is that what we define as property is deeply tied to our cultural perspective. And Canada being a multicultural society, this is a challenging aspect of defining property. Property and poverty. We pick property as a course because we end up talking about a lot of cases. But that disguises the philosophy of property. So the ideologies around property and the justifications for private property and the interests that are served by certain notions of property. So, for example, if property results in the ability to exclude, and this is self-expression, then property is self-expression, and that's wonderful. However, is the right not to be excluded also a right? And this deals with the income, inequalities that are in our society now. So, the importance of this is that the justifications of our notions of property are very important. Laforet mentioned the book by Ziff a lot and continues to mention the importance of talking about the justification for the notion of property. Income disparity, that's what I was looking for. So the statistics on poverty are terrible. It's 1 in 4 children in Canada live below the poverty line, over 40% of Aboriginals. But we don't focus on this in property law. We focus on the two parties in front of us, and thus that disguises how our notions of property are impacting the greater societal context. Possible exam question on page 91. This is interesting. Someone creates a wildlife reserve and charges admission. Can a neighbor charge a documentary film crew to set up in their yard to film the animals on the wildlife reserve? So from the person who spent all the time setting up the wild reserve and paid for the land, et cetera, are the actions of their neighbor legally permissible? Can they exclude them? And the issues here are very similar to the Victoria Park case. So is there property in the viewing of their property, in the watching of their property? Is there property in creating a venue that wild animals like to enjoy? I don't know. I don't know. And I guess that's why it's a good exam question. We'd have to examine it. I mean, there's notions of privacy, there's notions of nuisance. Do property rights extend to be able to exclude filming? If so, what is the justification of those rights? I don't know. Possession. Trespass and trespass on the case. These both relate to the interest in possession, not ownership. It protects someone who has the right to possession. So there's two types of possession. Actual possession, which means you actually have it, and constructive possession. So if you have your keys, then you possess your car. So it's a constructive or symbolic type of possession. And possession, of course, gives you certain rights. Perhaps not the best rights, perhaps not better rights, but certain rights. And this kind of helps to distinguish it in the context of other rights. So this is according to Roscoe Pound at Harvard. The least rights are known as custody. And Laforet sees this more as a spectrum than 3 divisions. So there's custody. Do you have custody? Is the book in your hands if you're at a bookstore? And then there's possession. And this adds the next element, which is the intention to exclude others. So if you have possession, you have the intention to exclude others. You pick a book up at the bookstore, it's the last one, you're on your way to the checkout, and someone comes along and tries to take it from you. Well, you have possession of it. It's not yours, you don't own it, but you have possession of it. And the most rights is full ownership, so once you actually pay for the book. So possessory rights, they are better than custody rights. And if you utilize your possessory rights to a land or object long enough, and exercise these rights enough, you may actually exclude the real owner. So if you move on to a vacant piece of land and start working it and build a house and you possess it, and you're exercising these rights because there's no one there to tell you otherwise, then eventually you can exclude the real owner in some certain circumstances. So how do we justify possession as a claim to title? How do we justify the fact that just because you have it, you can exclude others? And this comes from the Pearson and Post case in 1805. And basically what it means is that if we were to deny someone possessory rights, even though they possess it, the justification for that would lead to all kinds of confusing circumstances. So in this case, a person was hunting a fox, they were hot on the fox's trail, and someone else was just laying back on the beach, shot the fox, got the fox. And the person who was chasing the fox said that it was trespass on the case, because the fox was his personal property. He was intending to shoot the fox. He had put work, labor, and effort into getting the fox, but Pearson had the fox. So to take it from Pearson and say, okay, here, this fox actually belongs to Post, would mean that something that wasn't in his possession was actually his. So how do you determine that? Is it his when he gets ready to go hunting? Is it his when he sees the fox? So this type of confusion would threaten the king's peace, which is the original justification for trespass, and thus possessory rights can be used to exclude others. And we saw this too in, if you don't own a car, but someone lent you a car, you do have the right to exclude others. Your rights are better than someone else's rights. So you have a possessory right over that car. And that's what we learned in property this week.